Let's get you some analysis now. Legal analyst Kevin Smith joins us here in studio. Kevin, thanks as always for coming in. We appreciate your time.
Thank you, ma'am.
Some strong statements already being made by the lawyer representing these 10 expelled MK party members and MPs. One of them, that the leader of the party is a dictator. I just wonder, when they talk about putting their heads together to find a solution and to settle the matter, does that come into play, surely?
To some extent it does. If we think about how this matter has progressed over time, we see that the chances for settlement has always been there. It's just now a matter of what the prospect of that settlement actually is, given the terms that are on the table. Excuse me. As you've seen that Mr. Zuma and the former Judge Hlophe have given their directive as to how they want this matter to be settled. So I'm assuming that that would be the position that they either are going to negotiate from, or if they're going to be strict on it, negotiation might then fall away. But depending on what the terms are that they want to give to the expelled members, this matter may actually come to a conclusion quicker than we may have expected.
Look, we have no idea what this negotiation looks like. We have no idea what a settlement would look like. We're just sort of ruminating on the points that we have before us. But what might a settlement look like when these 10 out of 18 expelled members who have approached the High Court in the Western Cape have left jobs to become MPs? They've lost out now on the possible income, accommodation, flights, and the list goes on and on. Is it a financial settlement, do you reckon, that they're after?
That's actually a very good point. That could be something that is brought to the table, because when we think about them losing their jobs, losing accommodation, things of that nature, that speaks to the prejudice that they might suffer. So in an application of this nature, you have to put forward to the court what prejudice it is that you're going to suffer, and if it's irreparable harm. So for them resigning their jobs and the prospect of them getting their jobs back, getting their accommodation back, that's an irreparable harm that they might suffer. Right. So as you rightfully pointed out, and it's something that we may not have considered as the general public, it could actually be on the basis of financial settlement, because if they are, for instance, given the opportunity to be reinstated, what then happens to the incumbent nominees that would have been their replacements? Do they then have the same legal recourse? Because they might be in a similar position where they could say, we've also now left our jobs in anticipation of taking these replacement seats. Now we are suffering the same level of irreparable harm. Yeah,
correct. I mean, one of the other things is, I've got the stack of legal papers here in front of me, and obviously I can't find the page I'm looking for, but essentially what it says is that they make a whole range of strong statements about the fact that the running of the party, the running of the Umkhonto we Sizwe party, and one of the things that they bring to the fore and that they've told the court is that it's being run essentially at the whim of former President Jacob Zuma, the MK party leader, and the fact that there's an interim constitution that's in place, but there's actually no ratified constitution that is in place. Is that issue of the constitution something that the court might be declaring on, or might have the jurisdiction to declare on?
In my opinion, that's the biggest issue we're facing right now, and I'll tell you why. When you're in a political party, it's a voluntary association. So the relationship between yourself and that party is by way of a contractual agreement. That contract is in fact its constitution, because the terms of reference are held in that constitution. How disciplinary procedures are taken in that constitution. How you can actually join as a member are in that constitution.
And how you can be expelled.
Exactly. Now, them having an unratified constitution doesn't necessarily mean that it doesn't apply, because that draft constitution was circulated to all members. So all members have a point of reference to say that these are the points that our voluntary association is based on. But that makes it binding on both parties. So to the extent that the MK hasn't also followed their own constitution, whether it's been in draft form or it's been ratified at a formal conference, that doesn't necessarily become the main issue. The issue is that they had made a draft constitution, they had given it and circulated to all of its members, and that creates a reasonable impression to say that, okay, these are actually our terms of reference. This is the contractual relationship that is forming between us. So them not then following their own constitution, following their own provisions that they have made known to their party, that does then force the court to actually intervene and say, these are the points of reference that you guys should have actually done. These are the procedures that you should have taken in removing these members. By you not then giving them that allocation, they don't have the necessary or the adequate means to defend their position or to defend or mitigate the harm that they might suffer.
Yeah. So the fact that it's ratified or not ratified doesn't actually concern the court, because even that so-called contract between the party members and the party, it stands. It doesn't actually matter that it's a draft constitution.
Correct. As long as we have acted in accordance with it, that shows that there's, so in the law there's this thing called tacit acceptance. So tacit acceptance means that I'm acting on a reasonable impression. So once we start acting in accordance to the Constitution, whether it's still in draft form, shows that we, between ourselves, have agreed that it's binding in the interim. And that becomes essential because they have said that they are not going to be doing the elective conference or the national conference for some time. So it's a certain date in the future that we still do not know. And because they can't have an administrative oversight in that interim, we still have to conduct ourselves in a formal manner. So them having a copy of that draft constitution and us acting in accordance with it shows tacit acceptance between both parties, meaning that it is still binding even though it hasn't yet been ratified. The ratification process may bring in amendments or it may stand as it is, but that doesn't mean that we can't act in accordance with it in the interim.
I wonder, whether it might be in the particular interests of a particular person for that constitution to not be ratified. And for decisions to be made on a whim.
Correct. I think that is one of the main arguments that we've been hearing coming from the court, is that to the extent that there are no administrative barriers in place of dictatorship, it will be run as a dictatorship. Now, I personally wouldn't want to cast my opinion on why that may be, but if we can look at the conduct, not just with these expelled members, but with how the MK has found itself in court time and time again since their inception, it always leads us back to one individual making decisions outside the confines of the association itself. So that leads us to believe that the administrative barriers that should be there to make this a well-run organization are being kept out of place so that decisions are centralized within one person and that power is centralized within one person. And I think that's why maybe a settlement is now becoming necessary, because the court may then implore the MK to fix those administrative oversights. And that might take away the centralized power that they're currently now faced with.
Fascinating. And of course, this is something that Parliament cannot get involved in, right? We saw those 10 MK party MPs being sworn in by the National Assembly Speaker, Toko Didiza, just last week. But what these expelled members have approached the court for is for an interdict, right? They didn't want anyone else appointed in their positions while this case was ongoing. But the office of the Speaker telling them essentially, without an interdict, there is no legal impediment to the nomination or indeed the administration of the oath for these new MPs. So MK, as it stands, has 10 new MPs in Parliament.
Exactly. I'm actually happy you brought up the correspondence that was sent from the National Assembly. They essentially told these applicants that if you do not follow this directive, we cannot assist you. So they essentially said that the only way for us to intervene is if an interdict is in place, because if you look at it constitutionally, Parliament and the National Assembly has to carry on with its business unless a court order directs otherwise. And that's what an interdict would do in this instance.
Right.
Because the instances of harm that they may suffer, all of them are incumbent on the one before. So without me being an MP, I'm not getting access to my salary, I'm not getting access to the benefits, I'm not getting access to housing. So they all flow from the same, or from the first level of harm that they will be suffering. So Parliament doesn't have the power to intervene with the internal affairs of any political party.
Yeah.
Hence why
with very good reason.
Exactly. Hence why they want them to approach the court, so that the court has a jurisdiction to intervene where it has its discretion, where the internal running of that party is either illegal or it is being done outside of the prescripts of the law.
But I mean, the court's decision here will not be on a political party per se. This is a contractual issue at the heart of it.
Exactly. The court isn't necessarily going to waste its time in thinking about the political nature of what is happening. They are looking at this on the strict letter of the law, saying that these are members of a voluntary association. Their membership has been terminated. Was that membership terminated within the prescripts of the law itself or within the confines of the laws that that association finds itself in. Hence why they have to look at the Constitution as a founding document of the MK party to say what are the procedures in place within your internal structures that deal with this type of issue. Have they been followed? So they will look at what's called substantive fairness. They will look at procedural fairness. Do those things exist? And to the extent that they don't, then the court has the authority to intervene and say, this is how we think this matter should be dealt with. This is how we can repair the harm that may be irreparable. And this is what further directives need to be given to the MK party to fix these omissions so that this doesn't become a recurring issue.
Yeah. Kevin Smith, legal analyst, as always a pleasure talking to you. Thanks
Thank
for
you,
giving us some clarity around the big issues. As we count down to 2 o'clock, we'll take you back live to the High Court in the Western Cape, if indeed it does kick off at the 2 o'clock mark. But essentially what we're being told by our reporter, Malungelo Boy, is that negotiations have been taking place between the leadership of the MK party and these 10 expelled members since last week. Those negotiations are now continuing and a settlement might be on the books.